Welcome to the No Unfinished Business podcast. There are 1,000 different ways your clients can leave unfinished business, but no single advisor can address every issue. In every episode, we'll answer the important questions to help professional advisors focused on individual clients. Attorneys, CPAs, and financial advisors identify and eliminate those planning blind spots so you can speak competently and confidently to your clients and help them leave no unfinished business. Leah, thanks so much for joining me.
Thank you so much for having me.
So, Leah, you founded Trustate, which is something that gets at one of the real problems that I, as an estate planning and probate attorney, get into. When somebody dies, we have to go dig up and find all the stuff they own. And that is a task that's only getting actually harder the more digitally connected we get. It used to be we could count on finding statements or give it a month or two. Eventually, you'd get a statement from just about every account. But now we're getting pushed into, hey, we're going to charge you $1 a statement if we have to mail you anything. So everybody's going digital. Accounts are getting lost. Leo, what can we do?
Okay, sure. So let me give you kind of the long and short of Trustate. So not only do we help to find assets and liabilities, particularly of a deceased person in a probate situation, or when you're prospecting and working with a living client and trying to organize their affairs, whether you're working as the financial advisor or the estate attorney, we actually go and do all the retitlings or closings of those accounts. So one thing we've done, and I'll get into our history a little bit later, but one thing that we've done is it's not enough to just have the knowledge. It's actually the ability to do all the legwork that usually falls on the client to do to get everything closed out and buttoned up and in its proper place. We sort of run the gamut. We're there to help discover those assets and discover those liabilities, as well as bring everything to a close, if that makes sense.
Right. It's the two parts of it, or multiple parts. One, finding what's out there, because in a lot of cases, we're asking clients during the planning process, if you died tomorrow, would your kids, your parents, whoever it is who's going to be in charge, would they know where to find your assets? Do they even know where you bank?
Yeah. And usually what they say, and tell me if this is your experience, is I have a piece of paper. It's in my underwear drawer. It has a spreadsheet that has everything listed on it, or it's on my computer. But what's further compounds the problem is they think they know what they know about their own assets and liabilities, but even the most organized estates, whether it's an estate planning client of an attorney or an estate administration that we're working on, even if it's their closest loved one or someone who they themselves think they have a handle on all of that, they often don't even know what they own and what they owe. And that actually creates one of the biggest problems in an estate administration. And then further compounding that is the fact that as soon as you find an asset or liability, that's 10 more tasks you have to do to get that piece closed out as a professional who's working on it, or in an estate planning case, to get it funded into a revocable trust or moved or have a named beneficiary on it, or whatever else you might be doing to reallocate across spouses, for example.
Right. It's the sort of thing that it's just having that list, and we're doing that as part of the work we do, helping clients make sure we've got everything. At least we've got the good snapshot today when you're here. But it's rare that we get to the point at the end of the day where we say, okay, well, everything's done. We know if something happens to you tomorrow, we know where everything is. Now, I was working with a client this morning where we do know where everything is, because sadly they are not going to be around much longer. And so we really have dialed in. We've got a good idea of exactly where everything is going to be. It has already been funded into the trust so that when mom passes, there really isn't going to be a whole lot to do, which is good for them. We kind of got everything lined up. But that is the rare case. And it really is. Most clients, we're going to come in, we're going to do our best to keep in touch. But it's going to be years, if not decades.
Yeah. And I think that it's interesting because I bet, and tell me if this is true, for that client, you probably coordinated quite a bit with the CPA, as well as if they had a wealth manager behind the scenes. I'd love to know, was that the case with that client? Because typically it's making that coordination among a team of people who all come from different places.
Right. It's in this case because this was someone who we don't expect to be around for too much longer. We've already talked to the wealth manager and we're talking to the CPA in a week just to make sure we're not missing anything, as well as getting everything in place so that it doesn't create additional headaches for the beneficiary. The making sure that we're not setting it up so that there is extra tax on the plate for daughter when she
Yeah.
receives these assets.
Yeah, not to mention tax, it's the stress of getting everything done too. I think my background was as a trust and estates lawyer as well. And one thing that I don't even think I recognized while I was in private practice was that stress after that loved one dies and not having peace of mind because there's unknown gray areas in what they own and what they owe and how much work administratively needs to get done when somebody passes away. So you've done your client a really great service by and their next generation, that future client likely of yours, and that wealth managers and that CPAs, to get this work done for them and have it all set up and in a bow. So that way that family member, that daughter, isn't sitting there on a tax bomb, but also B, now doesn't have to call 1,000 different institutions to figure out what to do, how to do it, whether there's even any to-do items in the estate administration. So I think more firms should be like you and get this work done, obviously, ahead of time. And I will say, like, where Trustate can be helpful is we actually do that work ahead of time. We can help fund trusts back to us as an estate administration during life in a way. So we do all of the trust funding aspects from task completion, working with law firms like yours, as well as wealth management firms, to just get the task done and be the go-between and getting all the paperwork done for the attorney to guide their client through. And then also, obviously, on the back end, in the unfortunate situations where someone passes suddenly, or they didn't have a law firm like yours that gets that work done right away. But I think you are so on the money in getting that together for the client, because that daughter that you mentioned, she's going to be grieving the loss of a parent and trying to manage the whole rest of the family. I don't know the specific situations, but generally that process is very, very stressful and very awful. And being able to be a guide and to provide value at that point in time, just so useful. So I commend you for doing that work for your client.
Yeah, thank you. I know it from personal experience from when my own dad passed. Like we knew where everything was in part because there'd been a guardianship in place. So legally we were required to disclose everything. We'd gone through all of that. And even in that case, even knowing his death was imminent, it still took a lot just kind of when it happened. It was still overwhelming, pulling everything together, even knowing all we have to do is go to these 2 or 3 places because that's where everything is, still took a lot more time than we expected. And it, it's not necessarily the probate process that people do get wrapped up in because they always say, well, we need to avoid probate. You still have to transmit things from the decedent onto whomever it's going to. And that just takes time. It's just there are no easy answers on that one.
Yeah, you're hitting 2 points that I love to think of as common misconceptions in estates and trusts. One is that people think of an estate plan. They think all you have to do is get a will and trust drafted, and oh, everything's going to be great now. And I think back to estate plans that I did at a very high billable rate. And I'm like, this is a great tax plan. I've saved you millions of dollars. However, this is going to be a pain in the neck to administer because there's all those operational pieces that come after the fact. Because an estate plan designs the buckets where things ultimately end up. A good trust is a beautifully designed bucket that holds things and provides flexibility to those fiduciaries. However, a good estate plan doesn't, at least with testamentary documents, doesn't actually get the water to those buckets. That's all that work in your case on the front end, and in our case on the back end front end. It's being the aqueduct that brings the water to those buckets. So I love when people think, oh, all I need to do is get my will and trust done. I'm like, no, like sometimes, like, first off, you need to make sure you have a quality estate plan. I could do a whole other podcast on
No,
what that looks like. I'm sure you and I could both vent about things like that. But also, it doesn't stop there. And then the other kind of misconception I think in trust and estates is that, oh, well, we're probate attorneys. So probate to me is such a loaded term because some people use it interchangeably with estate administration. In my mind, probate, getting that client appointed, you're just putting them right at the gates of hell. Because now they are a fiduciary and they have all the responsibilities to do all the administrative tasks as well as make judgment calls that they need counsel on going forward to actually get the estate closed. You literally just got them appointed in their job and now they have to go and do the job. So I often like when people talk about how awful probate is and they use it interchangeably, I'm like, oh, no, like estate administration is the umbrella under which probate sits. And that's just the tiny beginning first phase. And even in some cases where we as estate lawyers can build wonderful plans to bypass a probate process in a very difficult state, it's still, there's still so much work after, to your point, in contacting institutions, in figuring everything out, and in getting just the 570 hours of work and administrative tasks done, let alone coping with grief at the end
right.
of the day.
Yeah, because it's usually somebody who's closely involved with this person and they've got their own issues. I mean, just their own emotional issues from having to sort through tying up that person's loose ends.
Totally, totally. And I think that's an area where the wealth managers and wealth management professionals can really key more into. As estate lawyers, we do this and deal with this all day long to the point where sometimes it can become transactional for the lawyer. But for that wealth manager, their business is relationships. So being able to work with that next generation and provide value is a way to work with them to grow AUM ultimately. So we see it as a great real retention tool to work with the family and the full family, right? As that wealth is changing hands by having a great relationship with an estate lawyer and having tools like ours at their disposal through either the attorney or the financial advisor.
Yeah, I mean, it's just kind of picking up on a few things that you've left out there. It's like the documents themselves don't do it. It's as though, and this is how I explain to clients, you're not buying a sofa that works in this house and will probably work in the next house. And maybe even if you paint the walls, it'll still be fine. It is something that you do need to pay attention to because your life will change and the people in your life will change. You'll get new assets, not necessarily I sold 10 shares of Exxon and bought 3 shares of Apple, but I opened this new bank account for whatever reason. We just need to make sure that we're doing that. And then the wealth managers and the CPAs, they're usually, they're a lot of my referral sources, which is great because they recognize the need for getting this plan in place. One of the things that I see as a gap between us, though, is they've got their checklist and they look and see, ask client about will, and if they've ticked it, they have done this. They usually don't say, well, when was the last time we asked? We asked a year ago, but not where is the original, as well as when was the last time it was actually looked at? Because when you get some older documents, they can have some issues where, oh, look, this child wasn't even named as the executor, even though they're now in their 30s. And it makes sense for them and not your father who's been dead for 10 years. It's just causing those little headaches.
Yeah, totally. It's so funny that you mentioned that. It's like there's not a litmus test to know whether someone planned appropriately by a do you have a will or not. In a lot of cases, an outdated will, it's better to not have a will at all. So I make that argument probably fairly often when I look at poor estate planning documents or outdated ones that haven't been looked at in forever. I've certainly, whether in private practice or through Trustate, have had to deal with implementing outdated estate plans because guess what? The milk spilled, the person died and can't go back. And
Right.
trying, at least in private practice, there's some mechanisms you can use, non-judicial settlement agreements in certain states, decanting, all sorts of different mechanisms that we as CE professionals use to help in those situations. But that costs people just so much money. And it could have been solved by a quick conversation with either that wealth manager, that CPA, or that estate lawyer on an annual basis of like, what's changed here? And then making those changes in their document. It's funny. I think you brought up like where the original documents are stored, which I love that that's something that's on your mind because that is always on my mind. I think we see enough lost will situations or mom wrote on her will and crossed out the name of one charity for another. Well, guess what? Now you're in probate court with the
Mhm.
attorney general and the two charities, and you're trying to work out a settlement, and it's big dollars in terms of litigation fees later. So it's interesting to hear you just bring up like will custody. And I have so much to say on this topic because knowing where that original is located, I think wills and trusts are one of the few things, really more so wills, where you have to have an original instrument and it needs to be preserved. It is a very like sacred document. To your furniture example, I give you this one. I view a testamentary document as the instruction manual where someone's entire livelihood and net worth passes. Sometimes it looks like IKEA instructions,
Right.
which still make a great thing. Sometimes it's easier to put it together, but in either case, that actual document itself is very valuable. It's probably the most valuable thing in someone's home in most cases. So
Right.
finding that original instrument or making sure that someone is storing it, whether it's in a fireproof vault at the law firm and it's stamped on top of the copies stored at so and so's firm, so important. So it's interesting you bring that up because I hear from a lot of attorneys and then other kind of platforms where they're not doing custody on the originals, which to me, then it's literally sitting in someone's junk drawer and they're crossing stuff out and now you're going to be in court.
Right. And I mean, it's lawyers don't all agree on this. I've got plenty of friends here in town, different firms that have made different choices. And I look at it on the other side of the wall from me. There are a couple storage vaults with lots of wills that we've signed over the last 4.5 years. And I look at that as it's a service I'm providing on a continuing basis. Yes, there is a cost with storing it and potential liability of having them destroyed and what happens. But this is where we're ultimately protecting the client and their intents because if most people, one, don't want to hold on to those things because they are important, they don't want to lose them. They just want to know that it's taken care of. So it's then back on me as the attorney, keep it in place, make sure that we know who they are and kind of we're checking with clients on a regular basis. Just don't forget, we have your documents so that if and when something happens, they know where to get the originals.
Yeah, I think I'm so glad that you do that. It's relieving to me. You should set up a debate session with your attorney friends who don't store them and the ones who do. I feel like we could probably go back and forth for hours on it. But, certainly because I sit very much so in the administration bucket right now, we do a lot of administration services, again, estate administrations, and then living trust administration as well. But it's a big problem and a much bigger problem than people think it is. And I think that's one of the reasons why a lot of the courts are so slow because there's never a straightforward situation because everybody has a lost will that literally, I can't even make this up, that's in somebody's basement, like a niece or nephew, and there was a flood, and now the document is completely destroyed because the attorney didn't store it or they used a service and a legal Zoom, if you will, and they had this document at home, not to mention other issues with that. So
Or, yeah, I mean, I've had one situations where people thought they had the original and then they handed over to us multiple times thinking it was the original because they've had it for years. Why would we have kept it? And it turns out, no, these were copies that who knows where in the years between when it was signed, you know, may have been left with the original left with the attorney. Maybe they accidentally handed out the original when thinking it was a copy. So many options. of where it could have gone wrong. And plus, a few years ago, there was a firm here in town during Harvey that was storing all of their documents in the basement of the building, which had never been a problem until you get a 500-year flood that not only flooded the basement, but flooded the first 2 floors of the building.
Oh my God. That is, I think, the worst story I've heard.
And yeah,
Wow.
so, so the good news was some of them were saved, but not all of them. And it's just going back and saying, oh gosh, we know it. At least we know what happened for some of these documents. We could say, look, I've had that situation as well. We knew exactly where it was. It was in this bank's vault. And when the bank went there to look for it, when we asked them to pull it out, they didn't have it anymore. And there were no records as to why it was taken out or when. And that's a better answer than we don't know. But here in Texas, if we can't find that original, even if we have a perfect copy, the starting assumption is the testator tore that up and threw it in the garbage because they hated it. And so we've got to overcome that presumption of why do we think it's just lost for no good reason?
So, question for you then, because I could see even in storing it, even with a risk that, like, in a 100-year situation, a law firm's vault that wasn't flood proof gets flooded and wills get destroyed. I would think that, like, when a person passes away who had a will there that needed to be probated or whatever, first off, the firm is definitely, they have good records. I'm sure they called literally every single living client and said, it's either wills from old estate administrations that are done, all
Right.
these living clients that they had to have them re-execute a copy of their other will, which is fine. They probably ended up getting extra business from it because people were able to update things. And then you have, like, somebody who passed away during the hurricane that now you have to go to court and explain why their will is gone, or they passed away before they could re-execute a document. So A, I think there's still better custodianship with even a firm holding it that, like, doesn't have a fireproof vault in a way. But B, and you tell me this, and maybe it hasn't come up. It'd be interesting if it's like a case of first impression. But I wonder if, for those cases, the law firm would be able to submit a pleading saying, hey, this was stored here. They did not revoke this. We had the original, but for this catastrophic event that happened that destroyed it, it wasn't that. To me, that's clear and convincing evidence that the testator did not request that will back and tear it up. So I'd be curious as to whether that would simply overcome any sort of evidentiary burden that's placed on the proponent of the copy of the will.
Right. The courts here, and having done this and seen it a few times, they're looking for kind of a reasonable answer for what happened. And
Yeah.
when you are propounding a copy of a will, you do have to get all of the heirs to sign off. So this is the risk. You've got to notify all those heirs, have them either waive or consent, or send them notice by, formal service.
Yeah.
But that's a risk. What if you have cut out the bad apple in the family who is an heir? You're giving them a chance to come in and say, clearly this is something was wrong. Now, in the case of something where the last will was in the custody of somebody else, it's going to be a lot harder for them to prove something has gone wrong or that they've, intentionally destroyed it. We can say, look, it was in the vault here. We never got any request to destroy it. Plus a hurricane came through. Like, we know exactly why. But you're not going to get around you still have to go potentially poke that sleeping bear who here
Yeah.
they weren't going to get notified of a probate because Texas doesn't require that you notify all the heirs. We provide notice once the executor or the administrator's been appointed.
Interesting. Huh.
Yeah,
Uh,
independent administration is one of the keys here, which it's why I conflate probate and administration. Generally, it's going to be a lot easier in Texas.
Interest certainly, and I'm sure you guys have, from what I recall, an abbreviated proceeding too for smaller estates and things like that as well. I think that the different state governments that cover this and the court systems, whether it's a surrogate court in New York or a typical probate court, or they call it the register of wills in some states, and an orphans court. A lot of them are coming out with sort of new ways to actually submit documents and ways for people to be able to work, particularly those where the estate isn't large enough to even hire counsel. There's ways for them to go in and get better service, but they certainly have a long way to go, I think, technologically to kind of meet that. Just, I don't know why it just sticks out in thinking through just the different options that people have and the different avenues they have to get in front of the court to get someone appointed.
Yeah, Texas does make it fairly easy. So if you have a will, there's not a small estate administration option,
Mhm.
or not. There is a small estate affidavit, but you have to have died without a last will. It is a kind of small eye of the needle to get through. And a lot of times we're just left saying, unfortunately, you can't fit within the bounds of this procedure.
Yeah.
But there is something similar for wills. If they die with a will, if they die testate, if there are no debts, we may not need a formal administration, but we have to go through, one, sending the will to the clerk because that is required. And so you had mentioned it. I know whether you call it filing the will with the county clerk, which
Yeah.
what I default to, but can be confusing. I know friends in California who say lodging the will, which just means we've sent it to the county clerk. We don't have to do anything after it. We're doing one step beyond that, where we're having the court admit it to probate, just saying, this is the will, it is valid, but we don't need formal administration. And then the beneficiaries can take the certified copy of the will and the order, and they can go around and just kind of wave that wherever they need to. We don't need an executor. There's nothing left to do. But you, again, have to have secured all the debts beforehand, because you're saying, look, we don't need formal administration because there are no debts.
Yeah.
And that's been an option that's been around for a while.
That's
For
so interesting. I think our tools could be really useful, like particularly the product that looks for liabilities to a Texas attorney and law firm then, just because we get that instantaneously. So you can figure out whether you need to go in and you can do this kind of abbreviated proceeding or not. So, super cool. And I've seen some states like that, but particularly in the Southeast, Mississippi is one as well, I believe, a slightly different procedure, but it's just interesting to see how the process varies widely here from state to state. And I think that's what makes this uniquely a US kind of problem, because in many other countries, the process, even if they have, even you take Canada, they have provinces. It's
right,
very similar from province to province. So there's not this kind of hodgepodge of different trust and estate laws. And you and I both know when you're drafting in the United States, you have different, even the Uniform Trust Code, the way it's adopted in New Jersey is different than the way it's adopted in Maryland. And it's basically like having a completely different set of laws than rather a uniform law, because our legislators have lots of opinions on these things, and each state has its own government and its own way of doing things. So it's interesting getting your perspective on that, because I think that's something that makes this process, I think, a little more unmanageable for end clients, for that family that's kind of sitting in the driver's seat trying to figure out the estate administration itself. Um, and I think that it's a unique challenge that solutions like ours can help solve, really, because we can work across all the states. Because even as a lawyer, I would get dragged into estate administrations all over the country, and I'd be like, I don't know this process, and I'd have to go and learn. And that was a lot of time that I was spending that wasn't good use of client funds. It also didn't help me in terms of, because I had to write it off. So there's
right.
ways to sort of shore up that process and provide kind of standardization where you can, and then nuance from state to state, and help with that. I think that's kind of the way to go. And that's where our solution is certainly one that encompasses that. And I hope to see more solutions on the market that kind of take that into account.
Yeah, I guess the thing I think about is we get a lot of people who move to Texas. I'm sure there are 49 other states that have people move from Texas. The nice thing is the will that you bring from somewhere else, even a California will, we can still get admitted to probate here with just a few extra words in the application. That part's not hard. The difference is it's like driving your car in third gear versus fifth gear. We're just slowed down a little bit because a California will isn't designed for Texas, and I'm sure vice versa, where you're just going to be missing out on something.
Yeah, yeah, and it's interesting. Even like the intestacy laws, where you don't have a law, like Texas's are totally different than other states. And you have some that have community property, Texas being one, California being another, and then other states that don't even, the lawyers don't even really know what that concept is. It's cool to see it from kind of like, since we zoom out, we see it across all states. And it's just interesting to learn about each state and their process and kind of the differences between them so that our attorneys can better serve clients.
Excellent. Leah, I think this is a great place to cut our conversation off for right now. If folks are looking to hear more from you or more about Trustate, where can they find you?
Sure. So you can go straight to our website. It's www.trustate.com. That's trustate.com. You can find us on, we have a LinkedIn page, Instagram, Facebook, Twitter. We're pretty much out there if you put us in Google, or you can reach me. It's Leah, Leah, at trustate.com. So pretty simple.
Excellent. Leah, thanks so much for stopping by.
Thank you for having me.
Thanks so much for listening. You can find more episodes, videos, and links to more helpful content at nounfinishedbusiness.com. If you have any questions, feedback, or ideas for topics, please reach out via social media or email John at john@stromeyerlaw.com. And of course, if you or your clients need help from John with an estate planning, probate, trust, or cross-border tax issue, you can book time directly with John at askjohnaquestion.com.